Live recording. I think we are now. Welcome to the First District Court of Appeals. We have only one case up for argument today. That case is Mees versus Mees, and the case number is C210187. Will the attorneys please enter your appearances?
My name is Robert Kelly, and I represent the appellant Howard Mees.
Thank you. Good morning.
Good morning.
Good morning. My name is Saba Alam, and I represent the appellee, Ruth Mees.
Good morning.
Good morning.
Mr. Kelly, would you like to reserve any time for rebuttal?
4 minutes, Your Honor.
Okay, I will be keeping your time, and I'll let you know when you have about 1 minute left,
Thank you.
whenever you're ready.
Your Honor, this is our appeal in this matter. And essentially what our argument is that the trial court has amended the party's decree of divorce in violation of 3105.171I. And it's modified that divorce decree because if you look at it, it's requiring Howard Mees to pay $125,000 for one of the pieces of property, when in actuality, he should be paying her approximately $36,000 by the language of the decree of divorce. However, the big issue here is that the receiver did not follow the terms of the decree of divorce in terms of what the parties agreed to, which was that all of these properties were to be sold, not liquidated by the receiver to say, I think you should receive X amount of dollars and this person or the wife will receive X amount of dollars. The clear language of Mr. Camp's marching orders was to sell the property, to sell all.
I thought that he was having trouble doing that, and that's why he came to the conclusion that he came to.
He never listed the Elmore property for sale. Even if he had issues related to the Elmore property, his receiver's report at page 7 that says, aside from providing Mees distributors rent-free warehouse space, the Elmore property is worthless. So if you look at the decree of divorce, it says that the property at that time was valued at $250,000 minus the 178, which would leave approximately $72,000 to divide. Now the receivers come up with pay Miss Mees $125,000, and the $178,000 has completely gone away. It's been eradicated. So the thing that I'm saying to you is essentially the decree states specific things, which is the properties to sell. And the property will sell even if it has to go up for auction. That property will sell. Mees distributors will sell. And the West Fork property will sell even if it has to go up at auction. Then whatever's generated from that auction will then determine what the parties are to receive, and then the receiver can do his math to divide it. The problem here is when you read the receiver's report, it's as if he didn't receive any money as a result of his services in this matter. He received almost $400,000 through the sale of the Columbus property and the Dayton property, which was largely the result of a real estate agent bringing buyers to the receiver. And essentially, what has to happen here is the trial court has to realize that this may be a bad decree of divorce, but it is understandable. And it does say specifically that the the receiver is supposed to sell the property. It's not to make a disposition as he deems appropriate. If you read that entire section and you read the other sections, every section in that decree of divorce states that the property will be sold, not that it'll be through divining by the receiver to determine what each of them should receive. And even the trial court said, well, we're going to make Howard Meese buy out Miss Meese out of the Elmore property, but we're going to let Miss Meese receive the rent for that property ad nauseum. And it's just not in the decree.
So specifically, are you saying that the decree was violated or the agreement was violated because the receiver didn't even try to sell the property? Because it might not, I mean, if he listed it, it might not have sold. And then he would have had to figure out what to do at that point, right?
You are correct. So if he lists a property for sale, and this is one of the reasons why we wanted an evidentiary hearing on this, in terms of knowing exactly what the receiver did or what he didn't do in terms of trying to sell the Elmore property, whether it was listed or not listed. We know that that the West Fork property was never listed. It was just all word of mouth. And the thing that we're saying is these items should have been listed for sale as it was specified in the decree of divorce and then sold. If they couldn't have been sold by a listing contract, then they could have been sold at auction. But that's where you're going to get down to where the real numbers are in terms of what each party is to receive and not what the receiver believes that Ruth Meese should receive because she's an older woman and needs money, because that's essentially what it boiled down to.
I was going to ask you, so you answered part of this, what you envision an evidentiary hearing looking like. I think the judge was concerned that you were wanting the judge to basically do a valuation of the properties, but you just said that you wanted to put the receiver on to determine whether or not he attempted to comply with the agreement.
That's one of the issues. The other issue is essentially to determine if the receiver is going to say, this is how I decide these values or what each party should receive. I think we should know what the values of these properties are in terms of when the court makes a decision. I'm going to give you $125,000. You've
Mr.
got
Kelly?
that decision.
Mr. Kelly, is anywhere in the decree say that there has to be an appraisal of the properties?
It doesn't say there's supposed to be an appraisal of the property. What it says, every property is to be sold. That's what it says. Every one of those, even the receiver's responsibilities, if the parties can't agree on how to list the properties, et cetera, his final decision-making authority is solely for the purpose of selling the property, and that's it. His decision.
In paragraph 10, the very first sentence says that he is appointed as the person to manage the sale and disposition of the assets.
And then if you keep reading that paragraph, if you go through that paragraph, Your Honor, and you look at that complete paragraph, and I believe that I have it right here. If you look at page 11, excuse me.
I have it in front of me. You don't need to find
Okay,
it. I
but
can read it.
if you look at it, his job is to make that decision or disposition concerning those assets as far as selling them, not divide them without coming to a realistic dollar amount. Howard Meese never agreed to pay her $125,000 for Elmore, never agreed to pay her for HLH, never agreed to pay her for the West Fork property. It's not in that agreement. even the receiver went beyond that and said, listen, since Howard Meese has a whole life policy with Meese Distributors, we'll give that to Ruth also. That's essentially what I'm saying is the judge essentially took whatever the receiver said and just rubber stamped it without doing an evidentiary hearing to say, how do you come up with these numbers? How do you calculate?
Can I ask you though, how do you reconcile the part of the agreement that says basically if the receiver cannot resolve the dispute between the parties, then he shall make the decision which is needed?
And if you continue to read through that paragraph that you just mentioned, it all talks about the sale of the assets. And if you look at paragraph 2 of that agreed entry, it talks about the sale of the Elmore property. If you look at the HLH paragraph, it talks about the sale. If you talk about Meese Distributors, that talks about the sale of the asset. And even the paragraph that you're reading, if you read that through to conclusion, it's all in reference to the sale of the assets. His disposition refers to the sale of the assets and not him just divining, well, you'll get this and you'll get that.
Mr. Kelly, you have about a minute left if you want to reserve 4.
That's
Mr.
fine.
Kelly- Mr.
I'll
Kelly,
reserve it.
Mr. Kelly, let me just ask you a question. Apparently the original purchase price of this property was $250,000. And it was my understanding that the court permitted both of the parties to lodge what I'll just call objections or concerns about the receiver's report. Am I correct in that?
You are?
Okay. All right. You answered my question. Thank you, sir.
Thank you, Mr. Kelly. I'll reserve your 4 minutes.
Thank
Ms.
you.
Allen?
You're muted.
Thank you. Good morning again. May I please the court? So I would just like to address a number of the things that Mr. Kelly has raised because I think the panel has brought up.
Ms. Allen, before you
Yes.
start, I want to focus you in on an issue that I've been wondering about. The receiver in his report said that the Elmore property was worthless other than use as basically warehouse space. So, but he awarded Ruth $125,000 from that property. Can you shed some light onto that, please?
I can. So Judge Bach, in fact, what happened with regard to the Elmore property was that we know that ultimately it was unable to be sold. And that's because Mr. Camp did experience a lot of challenges in liquidating the assets that were contained within that warehouse. They were having a difficult time with getting prices or valuations, and bidders did not want to bid when there was an unknown valuation of the assets that were within the warehouse, which he then identified as being worthless, although there was a value associated with the assets. So he did have a very difficult time in trying to get bids because the warehouse itself did not have a value. It could no longer then be disposed of as the parties had originally planned in the agreed entry 8-some years prior when they first memorialized the agreed entry. And so it was based on the parties' intent, which is something that Mr. Kelly did raise, and I believe that Judge Krause did also raise. He was appointed to dispose of the assets. The appellant, we believe, is this is too narrow of a construction of what the judge's order was. In fact, the trial court did state and recognize the difficulties over almost 10 years that the receiver had experienced in trying to dispose of the assets. In fact, in her agreed order appointing the receiver, she did specifically, identify and recognize the length of the case of protracted litigation, And in fact, she did also state in discussing the receiver's recommendation that the parties have ignored the requirements of their decree, and after nearly a decade of hindering the agreement, husband would have the court redetermine the value of the parties' assets and see them distributed in accordance with the terms that the parties have demonstrated zero interest in abiding by. And so these were the challenges that the trial court was faced with almost 10 years into this litigation that then led to adopting the receiver's recommendation, which in fact, the trial court had the authority to appoint a receiver in this case to carry out its orders. And her order was to manage the sale and disposition of the assets. While I recognize Mr. Kelly is pointing to and is focusing on sale within paragraph 10 of the agreed entry, that position, again, also is a very narrow construct. I believe what the intent of the parties was, as a trial court recognized, which was to dispose of their properties and to appoint Mr. Camp to be the final decision maker to that end. And that's precisely what happened. The trial
So there was no, is your argument that basically what Mr. Kelly's saying is that the court just rubber stamped what the receiver recommended? Is there no ability for the parties to challenge that and to question him about what he did and why he did it in maybe an evidentiary hearing?
To answer that, Judge Krause, yes, there is an opportunity to question that, and that opportunity was presented. The court ordered the parties to file responses to the receiver's recommendation, and both parties did file their respective objections to the receiver's recommendation. Furthermore, there's also case law that acknowledges and recognizes that the decision to adopt a receiver's report without a hearing is within the trial court's discretion. And that is from Shareholders of Paul Ann Corporation versus Paul Ann, which is out of the 10th District Court of Appeals. But that is case law, which also permits the court, even if objections were not lodged, to be able to adopt the receiver's recommendation in whole based on the trial court's authority. However, in this case, yes, the parties did both submit responses to the receiver's recommendation. I will point out, though, neither of the parties objected to his appointment.
So going back to Judge Bach's question so that I understand, with the property that the receiver said was not valued or didn't have any value, and now I think your client received $125,000 or is going to get $125,000 from Mr. Meese for that property? And on what basis is that?
Judge Krause, what occurred, just a little more detailed, was that Mr. Meese was to quitclaim that Elmore property to himself and Ms. Meese. The property was then going to be sold, and the proceeds would then be applied to the principal of a certain loan from Meese distributors, and the remainder was going to be split evenly between the parties. However, as we've discussed here today, it was never able to be sold, because of the issues related to the assets, the inventory that was there within the warehouse, and then the warehouse itself having no value, and potential bidders being weary of bidding on that asset when there was an unknown amount connected to those assets within the warehouse. So given this difficulty, given the 10 years of time that it was taking to resolve all of the balance of the issues in the parties' agreed entry, where the parties had agreed that if they were unable to get these issues resolved, that Mr. Camp would make the decision that needed to be made. And that is ultimately what did occur. The court adopted his recommendation after taking into account the record here, a lengthy record, as the court is aware, and giving the parties an opportunity to file their responses to the receiver's recommendation, and did find that by adopting the receiver's recommendation, it was going to uphold and carry out the intent of the parties in the agreed entry, which I will come back to say was to distribute their assets. And if that was unable to occur and Mr. Camp could not resolve the parties' disputes on that, he was permitted to make that decision, and the parties signed off on that decision. They agreed to that. They asked the court to make that agreed entry property issues a part of the decree. And then it
But
was.
for that property that was valued at $250,000 at the time of the agreement, there was a loan on it. And instead of taking off the loan and then dividing the amount, he just gave her half of the 250.
Yes, that's
What
correct.
happened? Okay.
Yeah, that's correct, Judge. He did do that. The receiver did actually do that. And again, I will point back to that it was a matter of this kind of bank of assets that the parties had, various bank of assets. This was not the only property at issue. It was not just the Elmore property at issue. So there was a way of kind of horse trading between some of these assets that the parties still had to be able to try to make it an equitable division. And
This was the only one that kind of stumped me as far as how the receiver came to his conclusion.
And so another part of this, Judge Krause, is that as part of the judge's order, the trial court's order, it did require the parties to provide all of the information, documents, be cooperative with the receiver in trying to help him to determine the value of the marital assets that were at issue. And the receiver, I believe you can also review in the record kind of the plethora of issues that he had in trying to get this information from the parties, but particularly from Mr. Meese in this situation. I believe there is a portion of the receiver's recommendation where he does set out that while he accepted the receivership appointment with the belief that there was going to be cooperation and trying to get everything kind of tied up, that was very quickly something that went away, and he realized wasn't the case, that Mr. Meese was moving forward as if the divorce decree was not put on and that there was not supposed to be any distribution of any more assets. So he really was encountering a lot of issues. And I do also want to address the issue of the evidentiary, of the violation, as Mr. Kelly has alleged, of section 3105-171, that somehow the adoption of the receiver's recommendation constituted a modification of the decree. And it did not. That did not consist of a modification for the reasons that we've discussed here today. The decree, which incorporated that agreed entry, is still a contract between the parties. And the court has to enforce and carry out the provisions of that contract between the party as it's written, and well-established law that the best intent of the parties is reflected within that document as it is written. And the intent of the parties, again, was to distribute their assets, have Mr. Camp to ultimately make the decision if they were unable to get it resolved on how that was to occur. So yes, there's also, case law. It is the Schrader case, which is cited in our brief, which does state that even though all of the elements may not be present within, even though every possible scenario may not be discussed in a given contract, that the absence of said statements does not warrant finding that the agreement was ambiguous if the document clearly conveys the party's intent. And that Schrader decision out of this very court stated that. And that's precisely the case here. Just because every single nuance perhaps of how some of these assets were delineated, determined, does not mean that the parties agreed entry of the divorce decree was ambiguous. Moreover, the parties also did agree and acknowledge that they agreed that the agreed entry was fair to them, and that they both knew the value and extent of their properties. So at this point, for Mr. Meese to come back and again seek to reopen that proceeding, is kind of the MO of what's historically happened in this litigation. It is an unwillingness to accept this finality that the parties weren't unable to achieve on their end, but also the finality through the decisions which they made, which was to have Mr. Camp be the ultimate, arbiter of how those marital assets were to be divided if they couldn't decide, and they couldn't. And that is what
You have about 1 minute left, just to let
Thank
you know.
you. If the panel has any questions, I believe that's all I have. And we do believe that the decision of the trial court should be affirmed.
Thank you.
Thank you.
Mr. Kelly, rebuttal? You are muted.
If you look at paragraphs 2, 4, and 6 of the agreed entry attached to the decree of divorce, each one of those paragraphs states that the Elmore property will be sold, states that HLH will be sold, states that Meese Distributors will be sold. If you go to paragraph 10 has a number of sentences, and it talks about the parties getting together to sell the assets. If it says, if the parties cannot agree on these terms and conditions, prices, etc., then he shall try to resolve the dispute between the parties. If he cannot resolve the dispute between the parties, then he shall make the decision which is needed. Now, if you continue reading on, it says Mr. Camp shall also be authorized to consult with independent experts as to the value of the assets to be sold. So there's no confusion. These assets were to be sold. There's no place that the appellee can point that says Mr. Camp gets to make the final disposition. He gets to make the final disposition as to the sale of the assets, but not to the distribution of them. And as far as the argument is Mr. Camp distribute them, they should not be distributed, they should be sold. If you want to know about the value of the property on Elmore, not only does Mr. Camp say the property is worth zero, but the contents of the property are described by Mr. Camp as, on page 3, you can put that inventory on the sidewalk with a "please steal me" sign, and no one could take it. So that's what Mr. Meese,
Kelly,
yes.
that was a buyer that said that, not the receiver.
Well, that it's in the receiver's report, referring to the contents or the inventory. And the bottom line is the inventory was never valued by the receiver. That's the second issue.
But wasn't it extremely difficult to do that, partly because of the parties, specifically Mr. Meese?
Not really, because essentially these parties had 3 tile businesses, one in Cincinnati, one in Dayton, one in Columbus. Mr. Meese cooperated on the sale of the Dayton and Columbus properties, and HLH paid for the transportation of all those contents which went into the Elmore property in order to facilitate the sale of those properties. Mr. Donovan actually is a person who obtained the buyers for those properties. Mr. Camp essentially went around and said, give me this book, give me that book. He never got a buyer for anything at any time in relation to any of these properties. All the work was done by Sean Donovan as far as that was concerned. And the bottom line of this situation is, you really, as you're sitting there, you really don't know what the value of any of these assets are any more than the trial court, other than what Mr. Camp is saying, because there was no evidence to the value of any of these properties or HLH or the West Fork property at any time in order to provide the court with a determination that if we're going to divide these things, at least we have some hard evidence as to what the values of them are. And that's all we're asking for.
Well, thank you, Mr. Kelly. You are at your time. Thank you both for your arguments this morning.
Thank you very much.
We will take the case
Thank
under
you.
submission and issue a timely decision.